Hey, hello everybody. How's it going, guys? I've been listening to my own music album to psych myself up in anticipation of the live stream. So yes, I put the link to the playlist in the chat that you've got on the right hand side of your screen, and I think this is super funny. So I used AI clearly because I used AI for everything. I've used AI to turn my contract law notes into music, into lyrics, and then music. And then I produced everything together in music videos that you can find on that playlist there. So far, they have done horribly. So perhaps people do not want to learn contract law via rap videos, but I thought it was such a funny idea. And to be honest, I like my own songs, so I play my own playlist in the background. So give it a shot by clicking the link that I've got there in the chat after the live stream, and then you can tell me what you think about it. So maybe we're onto something here. Maybe we can learn the basic concepts through song. Imagine that you can revise the whole of the FLK for SQE1 by listening to rap songs where I rap about the key concepts. Or maybe that sounds like a nightmare. I don't know. You tell me. How's it going, guys? So we are here today to talk about some more SQE1 FLK1 style questions. So what month is this? This is February. So we're inching towards the end of February, which means that now we are accelerating our preparation towards the July sitting. If you're watching this on the replay and you want to let me know how you're getting on with your prep, drop a message down in the comments, and I will make sure I reply to everybody with some thoughts, or we can perhaps share the pain as to how you guys are progressing with your preparation. Okay, so what we're going to do today, we're going to do what we normally do. We're going to go through some multiple choice questions, and hopefully you can't hear a lot of noise because I've got the washing machine banging on in the background, which is never fun. There you go. So a little bit of Disney brand placement, not sponsored. Right. So some SQE MCQs, and today the topic is tort. Tort law, the law of negligence and the duty of care. So as we're doing every week, I am going to share the slides that I have prepared, and we can start going through the questions together. Now, if you guys are wondering what this is, you can go back and look at a variety of other sessions that we've got. I'm doing this every Wednesday at noon to get together our community so people can get to participate and meet other candidates, and crucially at the same time answer some questions. All right, are we ready to go? So now you see the slide in the middle of your screen, and you see me at the top right hand side corner. So now, not too much emphasis on the visuals, but hopefully you guys can still see me jumping around. Okie dokie, so let's go. Right, so we are here. We are doing our live SQE prep. So let's go for our first question. Scenario 1, ladies and gentlemen. In scenario 1, what do we have? We've got Leo. Leo is a financial consultant. He advises clients on investment strategies. Sarah is a potential client. She attends a free seminar hosted by Leo, during which he discusses general investment principles but does not provide specific recommendations. Sarah later reads an investment report on Leo's website, which includes incorrect financial data due to a publishing error. Relying on this information, Sarah invests £50,000 in a stock that rapidly loses value. Sarah now wants to sue Leo for negligence, claiming that he owed her a duty of care to ensure the financial information on his website was accurate. Leo argues that he does not owe Sarah a duty of care because she was not his client and the information was not tailored advice. Okay, now, what is the question? The question says, using the Caparo v. Dickman test, This is the three-part test for the duty of care. Which of the following factors would be most relevant in determining whether Leo owed Sarah a duty of care in negligence? So the question is specific on the Caparo test and specific on the tort of negligence, because some of you might be thinking, hang on, this has to do with financial services, so maybe there are other pieces of legislation that come into this. Fair enough, but the question here limits your discussion to the Caparo test, which is used to determine what is happening in various situations where we don't have a pre-existing duty. And it provides us with a test that I'm going to go through in a moment to help determine whether the duty of care arises in these circumstances. So what are our possible options here? Option A, that's the question, right? Using the Caparo test, does Leo owe Sarah a duty of care in negligence? So option A, whether it was reasonably foreseeable that Sarah might rely on the investment report and suffer financial loss if the information was incorrect. Is that the right choice? B, whether Leo had a contractual relationship with Sarah, as duty of care in negligence only applies where there is a formal agreement between the parties. Is it C, whether Sarah's investment decision was entirely her own, meaning Leo cannot be held responsible for any financial loss she suffered? D, whether Leo had personal knowledge of Sarah's financial situation, as duty of care only arises when a professional gives personalized advice. Or is it E, whether Sarah's investment loss was significant enough to justify a negligence claim, as minor financial losses do not establish a duty of care? Okay. So the question was, under the Caparo test, which of the following factors will be most relevant in determining whether Leo owed Sarah a duty of care? Right. So let's have a look at the Caparo test. So the Caparo test was established in this case, Caparo Industries versus Dickman from 1990. It helps us determine whether a duty of care exists in negligence. And when are we going to use this test? As I told you a little bit earlier, we only use the test when we're not in a situation of pre-existing liability. What are the situations where we assume a duty of care? Occupier's liability is an easy example. The law imposes a duty of care in certain situations. For instance, if somebody comes into this building here and injures themselves because it's a mess around here, then I, as the occupier of the premises, will have liability towards them. We don't need to go through the Caparo test to establish liability in these circumstances, because that would be implied in there by statute. However, tort is the sort of situation where you don't necessarily have a pre-existing relationship with other people. That's the whole point in the distinction between contract and tort. So contract, of course, assumes a consensual pre-built relationship. Tort does not. You can have a tort when you breach a duty of care that you owe somebody else, even though you've never met them before. It's possible that you don't even know who they are. So if you cause a car accident, for instance, that could be that sort of situation. Now, what are the three elements of the test in Caparo? It says that a duty of care exists in negligence when we've got three elements: foreseeability, proximity, and it is reasonable to imply the duty of care in the circumstances. What do we mean by foreseeability? Was it reasonably foreseeable here that Sarah might rely on the financial report and suffer harm? Well, yeah, I think it is foreseeable. If you're putting financial advice or financial analysis, then I think it's foreseeable that people will use it to inform their investment decisions. So maybe we satisfy that one. But do we satisfy proximity? Was there a sufficiently close relationship between Leo and Sarah? That one is unclear. Leo did not provide direct advice to Sarah, which definitely counts against her if she's bringing a claim. On the other hand, Sarah is a potential client. She did attend the free seminar. Now, was the free seminar something like this here that you guys might be watching? Or was this the sort of seminar that you establish a relationship with the other party, you contact them in advance, they've got your contact details and so on. So I'm not sure about this one. So proximity might be a bit trickier. And the third would it be fair, just, and reasonable to impose a duty of care in the circumstances? I think this is debatable because the courts are reluctant to impose a duty on professionals for general statements as opposed to specific personalized advice. You can have a look at the case of Hedley Byrne versus Heller and Partners from 1964 for some additional information on this one. So, does Sarah here tick the 3 boxes in the Caparo test that will enable her to bring a claim against Leo? I don't think so. I think the correct answer here is answer A. Of course, that was it reasonably foreseeable that Sarah might rely on the investment report and suffer financial loss? That's the correct answer. And will Sarah be able, relying on all this, to bring a claim? I don't think so. Because even though we might satisfy the foreseeability requirement, I think we have difficulty satisfying proximity and whether it would be reasonable in the circumstances. So A is the correct answer. Remember, we're answering these things in the context of MCQs for the SQE. The way these work is that you're given a fairly chunky scenario and then you're giving a list of options. Remember that you're not looking for one absolutely correct answer amongst a bunch of totally random ones. It is possible that more than one of the potential answers might actually match somehow. So your job here is to pick the answer that matches the closest to what the question is asking. Admittedly, this can be tricky in circumstances, right? And also, this is made more difficult in the context of the SQE because you've only got about a minute and a half to make your selection as you're going through these really, really chunky questions. But that's why we're doing this. And the best way to prepare MCQs for the SQE is to practice. Go through as many of them as you possibly can in the time that you've got available. And also go through them in different formats. Come to these classes so we actually get to talk about it together in real time. Watch videos where either me or other people are going through MCQs and provide advice. Buy yourself some books like the FLK compilation books from Revise SQE that are very good, and have a look at those. Go and register for an online assistance like the law tutor that we've got from Law Drills, that for a small subscription, you get to practice AI-generated MCQs. You can even sit multiple choice tests that are timed and approximate the conditions of the exam for a small fee on that website. So try all these methods. And don't forget, you can also subscribe to my newsletter. So I sent you an MCQ that approximates the style of the SQE by email every Monday, and also reading materials, suggestions for study, tips, discount codes, and finally a fully articulated answer as to what is the correct and what is incorrect. Now, to finish off this one, we said that the correct answer here is A, whether it would be reasonably foreseeable that Sarah might rely on the advice. Now, B is incorrect because, of course, a contractual relationship is not required because the basis of the claim here is tort, not contract. C is incorrect because if C is saying whether Sarah's investment decision was entirely her own. This is not what we're looking for, right? It obviously she makes her own decisions, but the Caparo test gives us a different way of understanding this. D is incorrect because Leo doesn't necessarily need personal knowledge of the financial situation. And E is incorrect because, of course, the claim in tort is not dependent on the amount of loss. Now, clearly, if you didn't have any loss at all, there would be no point in pursuing an action, but significant loss is not a requirement. So the answer here, ladies and gentlemen, is A, whether it was reasonably foreseeable. That's one of the key things that we need to be looking at in the context of the Caparo test. But as we're at it, I would like to make a comment here that this is the reason why everybody puts a disclaimer for this sort of stuff. Now, having said this, I should put a disclaimer on these live streams to say none of this is legal advice, so don't rely on it. So it's important that people try to disclaim liability because especially in the context of providing either legal or investment advice, there's always some opportunity that the duty of care might be created, and then somebody might find themselves at the other end of the lawsuit when somebody makes the wrong decision and ends up losing money. That's why absolutely everything that you're going to see on YouTube that looks like it's offering advice for real life situations, it will come with a definitive disclaimer that says, do not rely on this. This is not legal advice. This is not investment advice. You're only looking at this, but you're responsible for your own stuff in your own way, right? So I'm sure that you've seen this a lot of times before. And if you're wondering, what happens with exclusions of liability that are in contractual documents or in notifications like this, you can have exclusions of liability that work and cover both contract and tort. Because normally in our live streams here, we talk about exclusion of liability as one of the features in FLK contract law when we're discussing how one might seek to exclude liability and then the extent to which they're allowed to do this, be it in a consumer contract or in a business-to-business contract. So we find exclusion clauses frequently. We discuss them in the context of contract law, but in the context of broader business law or tort, you might still find discussions of exclusion clauses, because it is entirely possible that an exclusion or limitation of liability clause will cover liability that arises either in contract or in tort. And that's why the Misrepresentation Act of, the Unfair Contract Terms Act discusses disclaimers of these things in contract and in tort. Okay, how are we doing so far, guys? Are we good? We got some people watching us live, which is awesome. Give us, hit that like button, the thumbs up, to tell us if you're having a good time. Yes. So if you're finding this helpful and you're having a good time, that would be awesome. So hit the like button, and if you can, put a message in the chat to tell me how much you're enjoying the show live. Are we ready for our second question? Let's move along. Where are we? Okay, so let's try and go to our second question. Scenario 2. So hopefully now the screen has changed for everybody and we see scenario 2. Okay, scenario 2. Greenwood Shopping Center. This is a large retail complex managed by Greenwood Limited. As he walks through the food court, slips on a spilled drink that has been on the floor for over 45 minutes without being cleaned up or marked with a warning sign. Mark, because of his fall, suffers a broken wrist and incurs medical expenses and loss of earnings due to time off work. Now, Mark is pretty pissed off about this. So he decides to bring a claim against Greenwood Limited under the Occupiers Liability Act of 1957. He argues that they failed to keep the premises reasonably safe for visitors. Greenwood Limited defends the claim, arguing that they cannot be held responsible for every spill and that Mark should have been more careful. Aha! So what is the question for you guys? Under the Occupiers Liability Act of 1957, which of the following factors will be most relevant in determining whether Greenwood Limited is liable for Mark's injury? Is it A, whether Greenwood Limited took reasonable steps to ensure visitors' safety, such as regular cleaning checks and warning signs for hazard? Is it B, whether Mark was wearing appropriate footwear, as his choice of shoes could have contributed to the accident? Is it C, whether Greenwood Limited intended for visitors to suffer harm, as liability under Occupiers Liability Law requires proof of intent? Or is it D, Mark's injury was severe enough, whether Mark's injury was severe enough, as only serious injuries created duty of care under the Occupiers Liability Act? Or finally, is it E, whether Mark should have looked down while walking, as visitors are responsible for avoiding visible hazards? Aha, okay. What do we think about this? Now, remember, people, this is English law. We are not in the United States. Therefore, don't think that this is an opportunity to make a killing by suing the shop in tort and raking in millions. If you believe American movies, this is what tends to happen in the US. And apparently, there's a whole industry of personal injury lawyers that work on a no win, no fee basis that gonna make millions for themselves and actually make millions for customers. So I bet everybody who goes shopping at Walmart and has a fall or something is thinking, yes, there we go, new iPhone. But it doesn't, I don't think it quite works that way in the US, and it certainly does not work that way in the UK. I did my work experience at the local solicitors firm in Colchester when I was a student, and they showed me a list that they had for compensation for personal injury claims, and it was peanuts. So, you lost an entire arm and you would just get like a few £1,000s. I mean, it probably got a little bit better since then because it's been a while, but still, if you see the sort of awards that you get for personal injury in the UK, it's really something that can adequately be taken care of by insurance. And it is not the sort of thing that's either going to make the victim rich or is going to kind of completely bankrupt the business. So, all right, let's come back to the question though. So this is in the UK, right? We're talking about the shopping center and all of that stuff. Now, what would be the correct answer here? What is the most relevant factor under the Occupiers Liability Act of 1957 in determining whether the company will be liable for Mark's injury? The correct answer here is A, whether Greenwood Limited took reasonable steps to ensure visitor safety, such as cleaning checks and warning signs for hazards. So A is the correct answer. Now, what does the Occupiers Liability Act require? This applies to occupiers, whether they're the business owners of the property or the managers of the property. In a domestic setting, it would be me, in my house, that sort of thing. So under that, any occupier owes a duty of care to lawful visitors to take reasonable steps to ensure that they're safe while they're in the premises. And to establish the liability, we've got a series of things that the court will consider. First of all, the court will consider the reasonableness of precautions. In our case here, did Greenwood Limited have a reasonable system in place for identifying and addressing hazards? If the spill had been left unchecked for 45 minutes, this may indicate a failure to take reasonable care. Second thing that the court will look at, was the risk foreseeable? Was it foreseeable that an unattended spill in a busy food court would cause injury? Yes, I think so, right? And the third thing that the court's going to look at is causation. Did the unsafe condition directly cause Mark's injury? Yes, it did. Okay? So if we have the test that is contained in the Occupiers Liability Act on what makes somebody responsible for the accident and then raises the issue of compensation, we're going to go through these steps. Is it reasonable were the precautions taken by the business reasonable? Was the risk foreseeable? And is there a causal relationship between the accident and the risk? And I think in all these cases, we can tick the boxes. Therefore, Mark will have a claim against Greenwood Shopping Center for the losses that he has suffered as a result of the injury, because the injury was brought about by their negligence. They had a duty of care that is established by the Occupiers Liability Act, and they breached that duty. Again, therefore, they are responsible. Now, let's go through the other options to be sure that we know why the other options are incorrect. B is incorrect, because even though his footwear might have been a contributory factor, and if somebody is found to be contributory negligent, this can reduce the amount of money they can recover in compensation. It still doesn't mean that the occupier does not have a duty, and it doesn't mean that the occupier did not breach that duty. This man did not fall down by himself because his shoes are broken or whatever. He fell down because there was a spill on the floor. Now, I would find it unlikely that the issue of contributory negligence would have a big feature here. So B is incorrect. C is incorrect because clearly the occupier does not need to have the intent to harm the victim. Okay, Because then if that was the intent, they were kind of digging trenches in the middle of the shopping mall to trap people, then this would be a criminal offense more than a tort. So C is incorrect. D is also incorrect because the duty of care applies regardless of the severity of the injury. Even minor injuries can lead to breaching the obligations, and the obligation to take reasonable precautions is there anyway. And E is incorrect because even though visitors are expected to take reasonable care, the occupiers are still obligated to ensure that the premises are safe, and that's why we've got this kind of three-part inquiry on the basis of the act. So the conclusion is we don't think that Greenwood took reasonable steps, so most likely because the spill was left unattended for too long. I mean, come on, it's not that difficult to kind of pick up some spilled drinks, is it? So I think they will be liable here. And in any event, the correct answer is A, because this is an issue of occupiers' liability, and they need to behave accordingly as a result. Right. How do we feel about this? If this makes sense, if now you're thinking you could have sued Tesco's for falling down or something, now you know why they might be liable. So think about it. What was it that caused your accident? So if you're enjoying this, let me know in the chat, or give us like the thumbs up when you're watching this either live or back on the replay. And if you're really spectacularly enjoying this, you know what you could do? You can also give me a super chat. So next to the chat, there is next to the chat line that we've got on the right hand side of your screen, there's something that looks like a dollar note. So if you click that, then it says you get to show your support to Dr. Yannis. So you can actually click that and send me some money, so then I can go buy myself a coffee and congratulate myself for having this great show. Right. And let's not forget, you guys can also join the channel as paid members. Now, what does that mean? It means that for only the price of a coffee, ladies and gentlemen, and the coffee is getting more expensive while my price remains the same. So for $2.99 a month, you can be a paid member of the channel, which means that you can see the totality of all the videos. And I've got so many videos covering the entirety of FLK1 and FLK2. You can become a member and you can watch immediately all the videos right now. Now, if you don't want to do that, no big deal. You're still going to get to watch all the videos eventually. They're all on a schedule. They're publishing like every Saturday. So eventually all the videos are going to be available for you to see. But if you are in a hurry and you also want to support me, you can either send us a super chat, or you can subscribe to the channel as members. Are we ready for our next question? Okay. Scenario number 3. Let's see what we're doing for scenario number 3. Olivia hires a Speed Fix Limited. This is a well-known plumbing company, and the idea is to install a new boiler in your home. Under the contract, Speed Fix Limited agrees to use high-quality materials and ensure the installation meets all safety standards. However, the installation is poorly carried out. The wiring is faulty, the gas pipes are connected improperly. 2 months down the line, a gas leak occurs, causing a small explosion. This damages Olivia's home and leaves her with minor burns and respiratory issues from inhaling the fumes. The explosion has also damaged your neighbor's property and causes injuries to a visiting friend, Jack. Now, investigations have revealed that Speed Fix Limited failed to follow proper safety regulations and used substandard materials. Olivia, her neighbor, and Jack all want to take legal action against Speed Fix. You will notice that this is not a multiple choice question, okay? Because I thought I wanted to raise the issue of the balance between tort and contractual claims, and that we cannot do very well through a traditional SQE style MCQ. That's why I put this in a more traditional problem question so we can have a think about this. So the questions: what claims can Olivia bring against Speedfix Limited under contract law, considering the terms of their agreement, and tort law considering Speedfix's negligence. In terms of Jack, who's a visitor, can a visitor actually bring a claim against Speedfix even though he had no contractual relationship with them? Now, 3, can Olivia's neighbor bring a claim for property damage caused by the explosion? And how would the court determine whether Speedfix breached the duty of care under tort law? And if we had any exclusion clauses or limitation of liability clauses, what would those do? Okay. Right, let's have a think about this. There's a variety of potential issues here and a variety of potential claims. And if you were to address this in a real life situation, then you would need to think seriously who you're advising and what are they trying to achieve. So this is good advice in every context. If you're preparing also for SQE2 and you're preparing for the advocacy parts of SQE2, I think this is important to keep in mind. It helps to put yourselves in the shoes of the person you're advising. That can help you structure your answers effectively, gather your thoughts effectively, and put your advice in a format that communicates well. So if we take this one at a time, Olivia has a claim against Speedfix, and Olivia has clearly a contract with them. Yeah. So what's happening here is that she had contracted for them to do that plumbing work in her house and install the boiler and so on. Do we have what she would like as a result? She would like compensation that covers the totality of the losses that she has suffered. What are those losses? You will need a repair on the house. You will need compensation for every other damage that has happened to material goods. You also need compensation for her physical injury, and there might be all sorts of consequential losses, which is loss of employment, medical bills, or sort of additional expenses. So she will want to claim for all of that through the contract claim that she's going to bring against Speedfix. Now, the basis of the contractual claim is going to be a breach of contract. So, has Speedfix breached the contract? The key issue here is going to be negligence. Have they been negligent in the provision of the service? The basis of this can either be the Supply of Goods and Services Act of 1982, if we were talking of a business-to-business contract, or the Consumer Rights Act of 2015, if we're talking about a business-to-consumer contract. It appears that here Olivia this is her own home, so she's doing this in her personal capacity, so the Consumer Rights Act of 2015 would probably be a better reference. Both these statutes, however, contain provisions for what we understand to be adequate service. So service that falls below the reasonable expectations is therefore negligence, and it is considered a breach of contract. And that gives rise to claims for compensation. So the way in which we're going to structure our advice to Olivia is to say, you want compensation for all these immediate and then consequential losses. The basis of your claim is a breach of contract. The reason why the contract has been breached is because Speedfix has been negligent in the provision of their service. An additional thing that she could argue would be that there's something wrong with the boiler. Therefore, we could argue that either the quality of the boiler is below expectation or the boiler was not fit for purpose. These, again, can be covered through either the Supply of Goods and Services Act for business contracts or the Consumer Rights Act for consumer contracts. It would lead to the same destination. Okay, so that's one part that has to do with Olivia. What about the bit that has to do with tort as regards other people? Now, would Olivia be able to base her claim in tort against Speedfix? Well, potentially, but it doesn't really make a great deal of difference here because the contractual basis is sufficient. The only reason that I see for exploring a tort claim in addition or instead of the contract claim would be in case the exclusion of liability clause that is mentioned at the bottom covered only contract and did not cover tort. Now, most likely, though, the wording in exclusion clauses is broad enough to cover both contractual violations and negligence that can arise in tort violations. We are not given this exact information in this problem question, so I cannot tell you 100%, but that's the reason why, if you could argue the claim in terms of contract and in terms of tort, why would you select one rather than the other? It could be that the treatment of the exclusion clause might guide you towards one way rather than the other, because the exclusion clause might prevent you from recovering in one domain but not in the other. So I still think that the contractual pathway for Olivia is sufficient here, so we can leave it at that. Tort, however, will be the avenue that the others pursue if they, because the others do not have a contractual relationship. So who are the others? Jack, who was a visitor, and what do you call it? Who else? The neighbor who suffers loss. Now, an interesting question here would be, who would they be suing, right? Would they be suing Olivia, or would they be suing the company directly? Now, this is problematic, and most likely they're going to be suing Olivia, because Olivia, as an occupier of the premises, is the one that has a duty of care towards the others. Now, for them to sue directly the company, then they would need to establish that the company had the duty of care. I think the distinction here goes back to what we had said at the beginning of our session today, where I tried to make a distinction between statutory basis for the duty of care and duty of care that arises out of circumstances using the Caparo test. If Jack, who's the visitor, and the neighbor want to sue Olivia directly, then they can sue her on the statutory basis on the Occupiers Liability Act. If they want to sue Speedfix because they don't have a direct relationship with them and there's no statutory duty because they're one set removed, they would need to use the Caparo test to say that the loss was foreseeable and proximate and caused the damage, and it's reasonable to imply a duty of care in the circumstances. Now, what is going to happen most likely here, I think from a procedural point of view, if you're thinking about structuring the claim, it would be that they're going to sue Olivia in her capacity as the occupier, and then Olivia will pass on those losses in her suit against Speedfix in order to be able to compensate them. So we have a complex scenario here that includes negligence and the treatment of negligence both in contract and in tort, and it raises issues that you need to analyze that touch on the duty of care, what we consider breach of contract, how do we understand causation, and perhaps on the next level, how do we calculate damages for the losses that all these people have suffered. You need to consider in this context either the statutory basis for this being the business-related side or the consumer-related side, depending on how you define Olivia's position. Now, finally, the idea of the exclusion clause, and the question that you've got at the very end, would the presence of an exclusion clause in the contract limit liability affecting Olivia's ability to claim? The interesting thing here is that with exclusion and limitation clauses, you can try to limit liability arising, as we said earlier, both in contract and in tort. That is fine. But there are certain prohibitions. So you cannot try to exclude liability for personal injury and death. And this is present in both in the Unfair Contract Terms Act and in the Consumer Rights Act. So excluding or limiting liability that results in personal injury or death arising from negligence is not allowed. So then the party in breach is responsible for everything in its totality. What this means in this context is that even if you had a successfully incorporated exclusion clause that does cover the dispute, it would only cover the physical damage, the property damage that's been suffered out of all of these problems. It would not cover the personal injury caused to the people in the question. Yeah. But that I would advise you to go back to other live streams that we've done already, where we talk about FLK contract law, where we've had the opportunity to discuss exclusion clauses in more detail. And I've also got some specific videos where I talk about exclusion clauses there and the whole the whole treatment of them. How do they get incorporated into contracts? How do we interpret what they say? And then how do they apply? Keeping in mind the restrictions that you've got from legislation as to unfair terms and how do we understand unfair terms to operate. So it's a nice area, right? So, I mean, I do enjoy that, and the discussion about exclusion clauses and all the rest of it, I think is super useful. And from a practical point of view, either you being involved in contract drafting, so you need to advise a client as to whether they should be including exclusion and limitation clauses and how to do it to be valid. And from the sort of victim's point of view, if you have a claim against somebody and somebody is trying to rely on an exclusion clause to avoid their liability. So having a good understanding of this area of the law, I think, is useful in a variety of contexts going forward, both for the SQE and the rest of your life. Because, I know that we're focused on passing the SQE here, but what's going to happen after you pass? You're going to become a solicitor, and then you're going to have to work with this stuff. So, the more you know, the better it gets. Alrighty. Are we ready for our next question? So let's move on to scenario number 4. And I thought I will pick something fancy for this question. So I created a multiple choice question in the style of the SQE that contains a lot of Latin. You guys remember Latin? Did anybody do Latin at school? If you did Latin at school, drop us a message in Latin. No. Drop us a message down in the comments if you did Latin at school and tell me what you thought about it. I did Latin at school. I loved it. I thought it was awesome. So I liked Latin more than I liked ancient Greek for some reason. And I'm a native speaker of modern Greek, and I still didn't like ancient Greek. I preferred Latin. There you go. Okay, now scenario 4. Sophia visits City Medical Center for a routine surgery. During the procedure, Dr. Patel, the surgeon, makes an error and leaves a surgical sponge inside Sophia's abdomen. Yuck! Sophia experiences severe pain and complications, requiring additional surgery to remove the sponge. She seeks legal advice on whether she can bring a negligence claim against Dr. Patel and the hospital. Well, she would, wouldn't she? During investigations, it is revealed that there's no clear evidence of what exactly happened in the operating room. But it is clear that surgical sponges are not normally left inside people's guts after the surgery, right? Yeah, you'd hope not. So the question, which legal principle will be most relevant in establishing negligence in Sophia's claim against Dr. Patel? Is it A, res ipsa loquitur? The fact that the injury occurred in circumstances where it would not normally happen without negligence. That shifts the burden of proof to Dr. Patel to show that he was not negligent. Is it B, novus actus interveniens? The hospital's post-surgical treatment was an intervening act that breaks the chain of causation, preventing Dr. Patel from being liable. Is it C, volenti non fit injuria? By agreeing to undergo surgery, Sophia consented to all potential risks, preventing him from making a negligence claim. Is it D, contributory negligence? Okay. Sophia must prove that she played no part in causing the harm, or else her compensation will be reduced. I don't think she stuck the sponge in her own guts there, if you get what I mean, but okay. E, the Bolam test. Sophia must prove that Dr. Patel's actions fell below the standard of a reasonable professional in his field to establish negligence. Right, a shocking turn of events right there. Sophia with a sponge in her guts. What would be the correct answer? The correct answer here, ladies and gentlemen, is A, res ipsa loquitur. This means that the fact that the injury occurred in circumstances where it would not normally happen without negligence shifts the burden of proof to Dr. Patel to show that he was not negligent. Yes? Now, why are the rest of them wrong? Or actually, let's define res ipsa loquitur first. So this applies when the accident or injury is of a kind that does not normally happen without negligence. Authority for this is the case of Scott versus London and St. Catherine's Docks. This is a case from 1865. Secondly, the defendant had control over the situation causing the harm. Well, yeah, I mean, because he's the surgeon and she's under anesthesia. And three, the claimant has no direct evidence of negligence, but the facts strongly suggest it. Well, duh, I mean, come on. Surely, this isn't normal. So, in Sophia's case, I think everybody will agree that leaving surgical sponges inside the guts of the patients is not evidence of proper care. And because this is an unusual event, the burden would shift to Dr. Patel to explain how the injury could have occurred without negligence. Aha. Now, why is option B wrong? It is incorrect because what this hospital did afterwards doesn't matter. Because actually, here, Sophia wouldn't be suing Dr. Patel in his personal capacity. She would be suing the hospital because Dr. Patel is an employee of the hospital. So what happens in this case, he's acting as an agent of the hospital. So the proper entity to sue would not be him personally, but would be him with the hospital behind him. And from a practical point of view, you want to do this because this is the sort of significant personal injury claim that would be quite hefty. So suing an institution or a corporation and not the person directly involved is usually a better idea because they're likely to have more money to be able to make good on any resulting compensation claim. So I know that the question here is saying that she's suing Dr. Patel, but I think the correct interpretation of it is to think that she's suing the hospital. Now, since she's suing the hospital, then Dr. Patel and the rest of the team are equally responsible for the mistake here, right? So trying to blame somebody else on the post-op team is not really saving the hospital. Now, that's why B is incorrect. C is incorrect because Sophia consented to the surgery. She did not consent to her guts being turned into a kind of washing basin with sponges inside, right? So you can consent to the risks involved in the surgery, but you do not consent to negligence. And we've seen this time and time again. In the law of tort, in personal injury cases or in cases where people have accepted the risks, but what happened goes beyond the risks that they accepted. Contributory negligence is incorrect. I mean, come on. Okay, the Sophia is under anesthesia on the operating table. Where's the contributory negligence? Her guts were in the wrong place. Okay, and E doesn't help us. The Bolam test applies when a medical decision or technique is questioned, not when an obvious mistake has been made. This isn't an issue about technique. Nobody leaves kind of surgical instruments inside the patient after they sewed them up. Okay. So this is kind of might sound plausible because it has to do with medical, but it is not what we're talking about here. Alrighty. How do we feel about this? If you guys are in agreement that the hospital got this wrong here and Dr. Patel and the hospital should be sued, hit the like button so more people get to enjoy this analysis. Okay. So, guys, thanks so much for tuning in today. It's been a great show. We're taking a break next week. So we're going to be back together when? We're going to be back together first week of March. As always, Wednesday at noon for another live stream. It's already scheduled. It's going to be on business law, insolvency, and how one can protect themselves in case of insolvency. So next show is going to be first week of March. I hope you guys have a nice time in between. If you want to hear from me on the Monday, make sure to subscribe to the newsletter. And I'm very happy to see you all. And I'll see you guys next time.